The Hynñiewtrep National Youth Front, HNYF, of Meghalaya has written a letter to Chief Minister Conrad K. Sangma raising questions on some points of the Meghalaya State Indigenous Peoples Protection Framework, MSIPF, Act, 2024. It has also demanded that before inviting investors under this Act, all its points should be discussed with all the stakeholders first, and till then it should be put on hold.
Today we have submitted a letter to the Office of the Chief Minister concerning the Meghalaya State Investment Promotion and Facilitation Act 2024. Our submission is based on the third point opposition to the Act because of certain unpleasant provisions that exist in the Act, because on perusal of the Act, which we have uploaded, we found that there are many provisions in the Act which we feel that it gave an overarching power, sweeping power to the government to speed up the land acquisition in favor of the industries which we can read as a non-tribal entities, which is against or it is in direct contravention to the Meghalaya Land Transfer Act. In our point 1, we have clearly stated that the IMA is only a facade, whereas the real power behind the IMA is the Governing Council and the High Power Committee, which both are chaired by the Chief Minister, and all cabinet members are included in both this power structure, and including other government officers. So IMA is the role of the IMA as defined in the Act 2024 is to become a landbank, to buy and purchase land, as per the directives of the General Council of the IMA and the High Power Committee of the IMA, which are chaired by the Chief Minister. So we feel that the Chief Minister will become, the political people, the highly powered people who are basically the political power, they will become the biggest landlord in the state of Meghalaya. They have the power to acquire land and they have the power to dispose of the land as per the convenience in favor of the investors. So, in this entire IMA Investment Meghalaya Agency, in the provisions Section 6 of the Act state that previous provision 6 of the Act says provision of the Constitution of the Investment Meghalaya Authority, that is Section 3, Chapter 2 of the Act, said that there will be a nodal agency called the IMA with the CEO as the Chief Executive Officer in the IMA. But if we look at Section 6, it clearly says that the CEO is meaningless. Why? Because vacancy extra of nodal agency not to invalidate any proceedings, which means the CEO is only a facade of the structure of the everything, whereas the real power will be in the Chief Minister and his cabinet colleagues. Section 6 said that no act or proceeding of the authority shall be ended merely by reason of any vacancy or any defect in the constitution of the authority, meaning the vacancy or constitution of the IMA. And number B, any defect in the appointment of person as a chief executive officer, means without the chief CEO also they can proceed. And number C, irregularity in the procedure of the authority not affecting the merits of the case. Any delay on the part of CEO also, the General Council and the High Power Committee can bypass. So basically, this whole IMA episode that is mentioned in this Act is a mere facade, whereas the real power will be with the Chief Minister and his cabinet colleague for the land acquisitions and everything, and allotment and distribution to the investors. So, if we look at this, we only feel that this has bypassed the schedule. Because the district council, I'm not saying that the district council is as exists in Meghalaya. I'm not saying that they are the owner of the land, but they are the custodian of the land, the constitutional custodian of the land. So if we look at the constitution of the General Council and the High Power Committee, which constitute of the members, chairman, the chief ministers and other government officers in both these committees, We nowhere find that the district council is incorporated. So how come the constitutional custodian of our land right is being bypassed by this act? And on top of it, we have traditional distribution who are the real owners of the land. So even I feel that the government, if it want to acquire land in the particular Hima, it should indicate in this law that the traditional head of this area also must be incorporated as per the requirement of the government in specific areas. That also has been bypassed. Section 34, if you look at this act, is not acceptable, because the heading of this section is an act to override other laws. Section 34 said that, save as otherwise provided in this act. The provision of this act shall have effect notwithstanding anything inconsistent therewith, contained in any other state law for the time being enforced, or any custom or usage, or any instrument having effect by virtue of any such law. Which means our custom will be bypassed, our usages will be bypassed, our tradition will be bypassed, even the district council laws, land laws also will be bypassed. Because this upper section of this act it indicates to that point, to that direction. So how can we accept this? How can we accept this? And if we look at they have empowered themselves so much when it comes to land acquisition, and on top of it, they incorporated Section 39 of the Act. Section 39 said, no suit or legal proceeding shall lie against the chairman or other members of governing council, high power committee, state investment committee, district investment committee, or nodal agency. No suit or legal proceeding. We feel that they can manipulate everything, and we cannot even issue. The people, the public, concerned people, the concerned authorities cannot issue legal notice, cannot sue them for any matter. How can we agree on the point that issue concerning land must be, must not be subject to judicial scrutiny? This is not. This is also not acceptable. You see, Section 36 of this Act it said that the government may from time to time issue general or special direction as they may deem necessary or expedient for the purpose of carrying out the objective of this Act. What does it mean? It simply means that the General Council, headed by the CM, and the High Power Committee, headed by the CM, they can even abrogate this whole Act itself to suit their interests when it comes to land acquisition and land allotment to non-tribal entities. And the most dangerous thing in this Act, the Meghalaya State Investment Promotion and Facilitation, is that recently we have seen that the Chief Minister has on many occasions stated that this Act is aimed at boosting or reaching a target goal of $10 billion economy and 5 lakh job opportunities. But as we can understand, we have as tribal people here in Meghalaya, we have a very limited land capacity. This Act nowhere mentioned about the moratorium or the ceiling limit for the industrial investors. There is also, we understand that land needs to be acquired for industries, like they have acquired in Jainti Hill for cement plant, they have acquired in Kiling River District and Rani River District for crushers and stone-based industries. They have acquired in many industrial park or industrial areas. We understand that context, but